Here to discuss, trial attorney Joe Richardson and criminal defense attorney and former prosecutor David Bruno. Joe, I'll start with you. What do you think the chances are that this gets to continue, this lawsuit by Abby Zwerner gets to continue in civil court?
My sense is, for the moment, they're going to be able to hang in there. Usually, state to state, as a general statement, when there's workers' compensation exclusivity being claimed, there will always be exceptions. Like in California, one is concealment. Typically it has to be something active by the employer that takes it past just an injury that's incident to the employment, something that unfortunately happened, it's no fault, it goes down workers' comp line. Here in Virginia, they're talking about heightened risk. So it's not just the risk of being a teacher, me slipping and falling in the classroom, me tripping on a desk or something like that. No, here's something that basically puts this in the employer's hands, and so therefore they shouldn't be rewarded by sending it off down the hall of exclusivity where there's less in the way of damages and recovery because they actually have some affirmative responsibility to do some things that they didn't do past the no-fault space. And so I would think that in a case where there's a gun, there's an argument that they knew about the gun and they actually didn't check for it, and he had problems before that made them have eyes on him. Parents didn't want him to be in special education, et cetera, they might be able to hang in there. They being the plaintiffs.
I agree. I think they got something to work with where as far as that danger doctrine goes. And David Bruno, when you look at this case, I want, full disclosure, workers' comp is something that is beneficial to actually both parties, but also the worker, right? You don't have to prove that there was any negligence. You don't have to go to court. You're automatically given damages as far as your medical costs and lost wages, but you lose out on the back end. It's a big difference between dealing with workers' comp and being able to sue in civil court where the damages can really be astronomical.
Huge difference, Michael. She's requesting $40 million in this civil complaint, and the school board is trying to limit it with nominal. I mean, really, it doesn't even compare. And look at this. This is bad policy, if you ask me. And I imagine that a lot of employees of companies don't even realize that this limitation exists. Yes, Michael, it is good. It is good that workers do not have to show fault one way or the other to get their medical bills paid when there's an injury at the workplace. But that's really for some of the more common injuries that we see. We don't really see 6-year-olds coming into a public school with a gun shooting teachers. And that's the argument that the teacher and her team are making here, is that this is not a reasonable injury that one would expect a teacher to have. Also, this child was problem for the last kindergarten teacher or a kindergarten teacher or prior teacher that he had trying to strangle the teacher, and also was accused of inappropriately touching another classmate under her skirt. There are problems after problems here with this individual, in addition to what we heard in that press conference, that they were aware that a gun was on property on the day of the shooting. So yes, I think this should go forward from a mere policy standpoint, given the fact that no teacher should expect to be shot in the chest with a gun by a student.
Fair enough, and I think that's the way this one might go. But I'll tell you what, Joe, the superintendent, the principal, the school board, they've got bigger problems because there is also an investigation on the criminal side looking into whether they might end up, based on that same set of facts we're hearing about how much they knew, et cetera, that they could face charges, criminal charges in this case. What do you think of the possibility of that?
Yeah, I mean, I think if there's ever a case where there's potential criminal liability here, a situation where there's failure after failure, where several people probably knew or should have known that there was actually an active gun on site. Not just that he had propensities to do some crazy things, but there was actually a gun on site that day. You have got to figure that someone ought to be potentially criminally liable that way. And of course, it's going to go according to the statute, but these kinds of facts are just extremely egregious, I believe. If it's true that they were told by someone, that some representative of the school was told that this person had a gun, and then they searched the bag or weren't allowed to search a bag, that they let the 6-year-old dictate what they could or couldn't search under these particular circumstances, then, that's a little bit of an issue. At the very least, if you don't search it yourself, you're calling the police, you're sexting someone off, so I think that there's a possibility for some criminal liability here, absolutely.
Yeah, no doubt about it. I think the one place that the school board, et cetera, does not want to see these facts that's in front of a jury, whether it be civil or criminal, because the facts are not in their favor. All right, Joe, David, stand by. Time for a break. Folks, disgraced former